My dad is joining us now because I wanted him to break down the two issues we're awaiting at the U.S. Supreme Court, one that we are a party to. So let's start with the case on ballot access, the 14th Amendment case. Colorado, of course, the Secretary of State there, up to the Colorado Supreme Court, said that they, under the 14th Amendment, Section 3, could remove President Trump. So even if you try to write him in, he could not, those votes would not be counted. Of course, the effect that could have on the general election as well. It was also happening in Maine. We saw it happen we represented states about 14, 15 of these, where most of the time we shut it down in liberal courts and conservative courts because they just thought this was wrong. But it made its way to the U.S. Supreme Court then with full briefing, full oral arguments, and now we're on week 3.
So the case was submitted February 8th, was when the oral argument took place. All the briefs been done. So the question then becomes, where's the opinion? And look, if it was unanimous, you would think it'd come out quicker. Doesn't mean it's not unanimous. It just could be there's different ways they're getting there. I am convinced we win the legal issue, that we're going to win the case. But there could be different rationales. We gave 4 different reasons.
Right. And I mean, I think one thing people are definitely concerned about is you get a Super Tuesday where the majority of people, listen, they're voting already in early voting in those states. Yeah. That if that answer isn't clear, it's not that President Trump won't win those primaries, but it does make it a little like there's a shadow.
To clarify, Super Tuesday is next Tuesday.
Yeah.
A week and a day is Super Tuesday.
Which tells me the court will rule this week.
Yeah.
If they don't, what are they doing here?
They're hearing arguments tomorrow and Wednesday.
So
those are usually opinion days.
Right.
But in a case like this, while they normally wait for an opinion day to read the opinion when they issue it, they don't have to here. The more complex issue is we all thought it was going to be, at least there was some thought it'd be per curiam, meaning the court was in agreement. But if one justice isn't, that justice could be writing a concurrence or a dissent, and that can take time.
Yeah, I mean, it seems like it's taking a decent
more time than it should.
But, if we get this Tuesday, Wednesday, that still clarifies it for the rest of the race, and it'll be a non-issue.
Is there a race?
No, I'm actually talking about the bigger general election race. To clarify this is, this is not valid. It also kind of takes away this that he somehow was a insurrectionist because if, so it takes that provision kind of out. You can always politicize that. But again, I think it would be very helpful for our election process long-term to handle this once and for all. I hope they do that in this case. It's not just tied to President Trump, but it's tied to the bigger pictures that this is not the process that can be followed, and we move on from these kind of issues. Because I could see this happening way too often on both sides of the aisle, trying to play this legal game of tying up candidates from being able to get into to actually campaign.
Yeah, so I think what we have to do is realize that right now they're probably finishing up that opinion. I think we win. I think you'll be on the ballot, and I think it does come out before next Tuesday.
It has to.
Let's go to the phones. Kat in Maine on line 3. Hey, Kat.
Hi. I'm not a lawyer, but I am an ACLJ member, and I'm proudly supporting. There was a show on 8 o'clock Sunday night on Fox, and it featured Mr. Mark Levin interviewing Professor John Yoo. I believe he's at Stanford or Berkeley.
Berkeley, yep.
And the discussion was about this provision apparently in New York law, as I understood the conversation, that in order to appeal, you have to put a bond up equal to the verdict amount.
That's correct.
So here's how it works with a bond.
Yeah.
It is for the amount of the decision, but it's only the bond it's a surety bond to make sure you're going to appear. It's a percentage of what is being, usually 10%. Now, in New York, because of some peculiarities and frankly the way they're treating this case, it's a little bit more unusual than it would be, because normally you'd put up, in this case you'd put up $40 or $50 million, and off you'd go to the Court of Appeals. Here it's a little bit different, but that's what appeal bonds are for.
Yeah,
to make sure that you're going to
if they fight against you,
the money's there.
That the money is there, so it's worth their time to be considering your appeals all the way.
But it's very expensive. Bonds are expensive.
Cost about they are estimating this one would, unless he just went out and was able to do it totally on his own.
$20 million.
About $20 million. That's money you don't get back. Like, you don't get to sue the state of New York to get that money
back. Correct. Even if you win.
Yeah. So I mean, you realize she's already taking a $20 million hit out on Donald Trump.
It tells you to be careful doing business in New York.
Yeah, it's sending a signal. I mean, especially, I haven't heard from Mayor Adams yet on this matter because politically it's kind of a minefield for a Democrat mayor. But certainly, he's getting phone calls from New York companies and businesses saying, we're not going to stay registered here, which means the majority of our taxes are not going to be paid here if you continue to do this in a global economy where we can get our goods anywhere we want.
Right.
Yeah, let's move on to phone calls. Let's go to Charles, who's calling in Tennessee. You're on the air, Charles. Go ahead.
Thank you, sir. I was asking, about the New York case with Latifah James. She targeted Donald Trump before she ever assumed office. If this goes to the appeals court, or say it goes to the Supreme Court, cannot a justice look at this and say, this was an illegal targeting of an individual, therefore the case is thrown out? That has to be illegal. I understand the...
No, one justice doesn't have that authority. One justice can issue a stay. In other words, right now in the D.C. court, there's a request for a stay as to this issue of absolute immunity for the president. One justice could issue that. It was sent to Chief Justice Roberts. Looks like, we don't even know that for sure, he's referred it to the court. But one justice cannot make a binding substantive decision. Right. It's a quarter-final review. It takes a majority. In that case, it takes 5 members of the court to come up with a decision.
So you still believe we get the 14th Amendment case sometime this week?
I'll tell you, if we're not, something else is going on. I think so. Especially, when did Logan say Super Tuesday? A week from tomorrow?
A week from tomorrow.
Yeah, I think so. I think we get it.
Yeah, and then that kind of put that issue.
Yes.
To talk about it for a day, and it push it to rest. But of course,
the immunity case is the one that's a little bit more interesting right now.
Yeah, because that's
you would have thought that would have been denied that stay initially.
Yeah,
but it could be a dissent from the denial. It could be they turned it into a cert petition and are drafting a question.
And you said those were filed that way.
Yes.
So in a way, that was almost opening the door to that possibility.
Well, he filed it as a stay, but the court on its own can.
Yeah, it was pretty serious.
Yes.
The filings were almost like a merits brief.
I think that's right.
Let's go ahead and take some phone calls. Yep. Let's go to Kevin, who's calling. Been on hold for a long time. We appreciate it. Kevin in California, you're on the air.
Hey, I have a comment about the Trump trial. So the Trump thing is unbelievable. If this sets a precedent, a mortgage loan, now you can look at any mortgage loan. And here in California, for 15 years ago, the majority of these lower-end loans were stated income loans. So you open up for no reason. There's no victim. The loan's been paid off. And somebody just decides arbitrarily to open up the file and go, oh, look it. You said you made $75,000. Now, the nature of a stated income loan is that you can't support with documents that income. That means every one of those loans would be subject to the government saying, wait a minute, because I don't like you and there is no victim, but I'm coming after you. Can you prove that you made $75,000? And that was a federally backed FHA loan.
Right.
This is why Kevin O'Leary kind of famously, maybe Elon Musk, have brought this up. It would be every loan. Oh, you said you worked, and this is just one box of a loan.
Yeah, I think, okay, so right here, I think New York, you talking about California, these are at the state level. And there are not many states that have this law. That is not the norm. In the most business-friendly states of the country, you're not going to be caught up in a civil fraud case because you got a loan from a company who agreed to loan you the money after what you submitted to them and after they did their due diligence and that you paid them back. So that would be it. This case state would have nothing to look into. But in New York, you could do this without a victim. The victim, they're saying, is the state of New York that was defrauded somehow. And again, it's a way to they think to push Donald Trump out, and of course, punish him and push him out of New York City. But you look about it in the bigger picture and you say, Logan, this pushes lots of businesses out of New York City. Now, some have to be there, but what you do is you would minimize your assets.
Your headquarters may not be there.
You'd minimize the assets.
Doing business. I saw Jimmy Petronas, CFO of the state of Florida. He was putting out social media posts just overnight, last night, saying, hey, if you're one of these New York institutions, you want to move yourself to Florida, reach out to my office. So, I mean, now Florida, these states that are a little more accommodating are going to start marketing. Bring your business here and like directly on social media.
Like that, I mean, with Oracle building up a huge.
Well, I mean, you hear about it like obviously they contacted. You don't see a lot of Instagram posts of take your business out of New York and bring it to Florida.
Yeah.
But you have great leaders like Petronas that they're doing that, so I appreciate that. But it is interesting to see that that's going to become a talking point, also beyond people who can or will bring up business one way or the other. But it will be a conversation that's happening. And another boost to Florida, another boost to states like Tennessee.
It's like if your
Texas.
business is not politically aligned with the DA or the attorney general in that state that somehow, because your business is aligned with their politics, though you follow all the rules, that you're going to be the targeted more than someone who gives campaign donations to that person. And that is not a city or state you want to be doing business in. You can still do business in, but you minimize your assets and you minimize what they can take from you, because New York can't go to Florida to take Trump properties.
Right. Let's go ahead and go to Jeannie, who's calling in Oregon on line 1. Jeannie, you're on the air.
Thanks for taking my call. I listened to you guys for years, and I appreciate all the information you share. Considering what happened when the Supreme Court made the ruling on Roe versus Wade and how they even experienced personal trauma in their lives, do you think that is going to be a factor in their thinking in this
just the nerves
Amendment 14?
You'd hope not. The nerves of the fact they had people doxing them or showing up at their house and those kind of things that wouldn't impact. And you'd hope the people who selected the Supreme Court are maybe stronger than that. Yeah. But I'm sure it's crossing your mind.
Wade and that was actually a bigger deal than this Colorado ballot issue, and a bigger deal than even like presidential immunity, because this would not just be about Donald Trump's immunity, it'd be about future presidents' immunity. They're a little bit more heady. I think also there's a lot of people out there who don't like the fact that a Republican Secretary of State could decide to take a Democrat off the ballot, who's the most popular Democrat. So, again, I think the Supreme Court is more nervous. There's a lot more security there than ever before, obviously. There's potential for more cases involving Donald Trump to end up at the U.S. Supreme Court. Now we're talking about the Eighth Amendment issue. I mean, that would be another issue that could work its way through the state court system and ultimately still end up. You could go from the top state of any court. So in New York, it's not the state. The Supreme Court is the district court, but the Court of Appeals is their highest court. And once you finish out in the highest court, you can always appeal. You can appeal those kind of constitutional decisions directly to the U.S. Supreme Court, like the Eighth Amendment issue. I mean, look, that's why, again, you wonder with what's happening in Georgia, and again, how the Supreme Court decides on immunity. Like Dad said, they could even turn that into a merits case. Yep. Is that whether any of these trials will even proceed very far before the November election.